one of the things I do when I teach at the NITA programs or other law school programs that I've been to is don't put on your suit and strip away your humanity. Because oftentimes we want to look like lawyers. We want to sound like lawyers. And that may be your goal. But if you're yourself and you are genuine to who you are as a human being, then you're not speaking as much like a lawyer and you're not doing things like you think lawyers should do. You'll have people telling you, oh, Mr. Milanfar, you need to act this way. That's not how you act. Well, that's fine. But if I'm not myself, I'm not being effective. It really is a piece of self-discovery that we all have to do in order to be the most effective in how we present our client's case. And there's some lawyers who, walk on water, right? They're so slick and so smooth. I don't find I could pull that off. So why am I going to try to be like that person?
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I've been looking forward to sharing part 2 of this conversation with Shahrad Milanfar. I want to fast forward now to January of 2020. And maybe before we get there, what led to you opening your own firm?
So my prior firm was in a transition, and I decided that it wasn't the best thing for me to stay there and, partner up with the people that were there. And I was getting recruited by some other firms who were all good firms and, it would have been good opportunities. But I'd always had it in my heart somewhere that I wanted to make my own decisions. So ultimately, I decided that that was the best approach. And, my wife was, behind that approach. And, she's a lot smarter than I am and much more planning wise. She does a better job. And that really helped because I'm the kind of person it's like, I'll just do it and figure it out as I go along, as opposed to asking all the right questions from a business standpoint anyway.
Your wife has a background in big law in terms of being involved in leadership in a large law firm, correct?
Correct. So she used to essentially help run the operations in a nonprofit before, and then she joined a large law firm and she worked in HR and eventually became an HR manager for that law firm.
Okay.
So anyway, basically, the biggest thing for me was not being a 90-year-old wondering what could have occurred. So at the time, obviously, there was some whispers of COVID, but nothing that was concrete. So we opened the firm January of 2020. And then come March, all of a sudden, the entire world changed. And that really was a good lesson for me in the sense that, look, I had to look back and say, look, your family has had this happen. COVID is no different. Are you going to adapt? Or are you going to say, oh, this is too much, I'm going to go work for somebody else and be that 90-year-old?
And because you and I had the opportunity to chat a little bit before we started, I understand what you mean when you say this, and this. But for those who weren't privy to our conversation, can you unpack that just a little bit in terms of the idea? I think a lot of people hearing this would say, oh my gosh, you have opened your own law firm and the world has shut down. That is terrifying. So how has your family background living through the revolution and the Iran-Iraq war altered that, your perspective, so to speak, in terms of having a different view of the risk and terror that might come with that?
Naturally, right? My normal instinct is to avoid the hard things or conflict and all that. But I've really trained myself to move toward those things, right? When you live through a war and a revolution, and then you come to the United States and you grow up in Oakland, right? You have to look at it and say, if something is occurring in my life, is it occurring in a way that if I put it in context, it's just as dangerous or stressful as what I've already been through? right? And as we talked about, I think, again, I'm not discounting any of the horrible things that people deal with health situations and everything else that all of us have had to deal with in lives or extended family have had to deal with. But overall, I try to look at it from a sense of being grateful for not living in a country where you and I are worried about that window breaking because a bomb just fell out of the sky, right? So that really helps in terms of perspective, where when COVID hit and all of a sudden the world changed, we had to look at it and say, all right, how do we change things? And as we talked about, there was a lot of lawyers who I'd known previously who, when they found out I was starting to do plaintiffs work, they were referring work to me, they were calling me, and they were just giving me advice. And one of them is a friend of mine said to me, in 7 years, you're going to call me and say, this was the best decision that I've ever made. I called them in a year and a half and said, hey, this was the best decision I've ever made. I then called them the following week and said, it's all your fault. I'm having a horrible day. You convinced me to do this. But ultimately, it wasn't an easy thing to do. And, when you look at it, your financials are all tied to this business. But I was committed that I was never going to have to go to any of the people who followed me into this venture and say, you know what, we ran out of money and we don't have money to pay you. And I took that incredibly seriously. And that was a motivator, because not only did I want to help the folks that we have in our firm, I also wanted to bring our firm to a position where we could do good in our community. And that's something that we've been able to fortunately do based on what's occurred during the last 4.5 years.
I believe we touched on this, but maybe not as specifically as I should. You now work with your wife, is that correct?
That's correct. She's our chief operating officer. So she's responsible for the business side of the firm, and I basically focus on the legal side.
Would you say that plays well to both of your strengths?
I think it does, in the sense that I'm not as, good, obviously, in business, and I have a lot to learn, and she has a lot of experience and, knowledge that I don't have. The hard part is basically, making sure that we're in line and that everybody says, oh my God, you all work together. And that's the hard part, right? Is being able to balance the home and the work approach. But at the end of the day, this is someone who is working shoulder to shoulder with you, and you trust implicitly. I don't have to look at my bank accounts, right? And that's an incredibly comforting feeling when you know that if I say, please get this done, it's done. I don't have to worry about that.
This is a loaded question. How do your children feel about the two of you working together? And the reason I say it's loaded is because in our household, we get will you two, please just stop talking about work. How do you manage that in terms of having kids and having a household and not being so involved that it occludes other things?
Our son, who's in high school, has kind of been there for the whole thing. Our daughter is an adult, so she lives in another state and hasn't been as involved in that. But he jokingly says that he's a founding partner of the firm because he was there when we were setting up the furniture when we first started. And he tells my wife that he outranks her because he was there before she started actually working at the firm. So, he has good fun. But you're right. I think working with each other and owning your own business a lot of time engulfs your entire existence, because dinner time sometimes is, hey, did you talk to so-and-so and da-da-da-da. But it is what it is. But we have to kind of try to keep a balance, which is difficult. At the end of the day, our mission is to really be there for our clients. And I think what we put in, we get back tenfold. And that's really what's satisfying about the whole thing. My daughter was always frustrated with me because I would always identify the dangers in our environment. And she says, you're so paranoid. Well, I've seen what happens.
No, honey, it's called hypervigilance.
Right. And it's true, right? Because I've seen what happens, and I talk to our kids about our cases, right? Because, I've had my son, I talked to him about a case a few years ago, and he's like, that's BS. And I knew that case wasn't going to go anywhere, right? So they understand the big picture, but I think they're also frustrated because I'm so hyper vigilant about things. Like, I teach them how to drive defensive driving. Assume everybody's going to make a stupid decision and drive that way. But they also realize that the type of work that we do affords them a certain lifestyle, and they don't mind that aspect of it. And I think the biggest thing for me and our kids is, I had a conversation with my daughter recently who, called me up out of the blue and said, I just want to tell you, I'm really proud of the work you're doing. Right. You seem to really now flourished in what you're doing. And that's an awesome thing. And ultimately, what I want, hopefully, right, and I will confess, this is not a successful mission every day, to model to my kids how to live your life in a way that allows you to be content and happy, even though I fail most of the time in that endeavor.
As we talk about your son, he has absorbed some of the advocacy side, it seems. Can you tell us a little bit about his involvement and your involvement in the Port of Chicago disaster and the exoneration of some of the individuals there?
Absolutely. So for the listeners who don't know about Port Chicago, this was a massive explosion in Port Chicago, which is near Concord, California, in 1944. It was July 17th, roughly around then. And the people who were loading the ammunition, and at the time, the U.S. Navy was segregated. So the black enlisted men were loading the ammunition, and the officers were directing how this was done. So there's tons of stuff out there on the Contra Costa County Bar Association's task force website that people can look up. But ultimately, this explosion was one of the largest, if not the largest, land-based explosion in the United States. And there were 256 black sailors who said, hey, wait a minute, you want us to go back in and clean up the debris and the bodies and all that? What are the safety protocols that are in place? And they were told, you either go back to work or you get court-martialed. 206 went back to work, even though they did get court-martialed. 50 of them did not and were tried and convicted unjustly of mutiny. Now, they had 5 lawyers for 50 men. So imagine 1 lawyer for 10 clients who are being charged with a crime that's punishable by death. This conviction stood. Even Thurgood Marshall, our former Supreme Court Justice, attempted as the chief legal counsel, I believe, of NAACP to help with the exoneration efforts. It didn't work. So we fast forward 80 years later. My son hears about this because I was talking to one of the task force members, and he says, what is this all about? So we met with the head of the task force, Jonathan Lee, who sat us down for an hour and a half and gave us a college level history lesson, which was incredible. At the end of it, my son says, how can I help? And Jonathan was, the incredible human being that he is. He's like, well, you're good with social media, right? Yes. And he then put my son in charge of helping with the social media of the task force. And eventually my son was made a member of the task force. So fast forward to July 17th, 2024, the Secretary of Navy signs an exoneration order exonerating 256 black sailors who were unjustly convicted. And how great it is that even though it took 80 years for this civil rights injustice to be fixed, it's not truly fixed, but at least a step in the right direction. I don't see as an immigrant that this would happen in any other country. And for a 16-year-old to see that other human beings care about others and are willing to work toward this sort of thing was just incredible. And I told him, I said, now you're part of history, right? Because these men's names have now been cleared, even though it's 80 years later and they're no longer alive to see this happen. Why? Because people who weren't even born when this event occurred actually cared about that sort of thing and correcting that injustice.
Does he your son give off the vibe or intention of possibly following in your footsteps?
He's expressed interest in that context, but it's not because I'm pushing him to. I genuinely, if he decides to do it, I want him to do it for him, right? But based on the Port Chicago experience and the work that we're doing and the verdict that I got recently, he's very much interested in it. And it was funny, he just participated in a mock trial in a law and society class that he took. And it was him and his partner, whose parents are both incredibly accomplished trial and appellate lawyers. And I jokingly told them, if you lose this trial, you're going to be forever shamed, because between the two of you, you have coaches that have like 90 years of experience. But they seem to enjoy it. And I think he goes with me when I judge mock trials. Like I've judged mock trials for Hastings and or formerly known as Hastings and UC Davis. And he'll sit in at these mock trials and he will then give me feedback. And it's miraculous, the insight that he has. And the beauty of that is he's not jaded by law school yet. So he understands what normal human beings' reactions are to how lawyers interact with the public and the jurors. So it's fascinating getting his feedback, because I feel like I'm getting a normal perspective on what the feedback would be if I were to talk to a juror about a case, which is amazing.
I hope that if he goes to law school, that is the type of thing that he can maintain, because sometimes that is a challenge, isn't it?
Absolutely. And one of the things I do when I teach at the NIDA programs or other law school programs that I've been to is don't put on your suit and strip away your humanity. Because oftentimes we want to look like lawyers. We want to sound like lawyers. And that may be your goal. But the question is, do you come home and tell your mother, on the night of April 8th on the northwest corner of such and such street, I witnessed a collision between two vehicles.
Suddenly and without warning.
Exactly. But yet, this is the way we describe things to juries and talk. And one of the best feedbacks I've gotten from jurors is that I speak like a normal person when I'm in trial. There's sometimes you can't avoid it. You have to use technical terms because that's just the way it is. But at the end of the day, if I'm talking like a normal person, it makes it a lot more palatable for a juror to listen to what I have to say, as opposed to sitting there listening to legalese for 8 hours a day.
Did you manage to avoid going through the period of time of going to law school and then speaking like a lawyer, or did you unlearn it?
I think Bernie Siegel's approach was one that really helped us become ourselves, right? But one thing he taught us is decorum in the courtroom. You will never see me sitting down and opening my mouth in court. I've been invited by judges, please, Mr. Milanfar, sit down. No, Your Honor, I prefer to stand. Why? Because I want to have that decorum. But that doesn't mean you have to be stuffy. One of Bernie's famous quotes was, if you can't get a good result, get a good story. And one of the things I learned from that is, if you're yourself and you are genuine to who you are as a human being, then you're not speaking as much like a lawyer and you're not doing things like you think lawyers should do. And I don't know when that transition was or how that occurred, but I think everybody goes through that, right? Because you'll have people telling you, oh, Mr. Milanfar, you need to act this way. That's not how you act. Well, that's fine. But if I'm not myself, I'm not being effective. So it really is a piece of self-discovery that we all have to do in order to be the most effective in how we present our client's case. And there's some lawyers who, walk on water, right? They're so slick and so smooth. I don't find I could pull that off. So why am I going to try to be like that person?
You've mentioned NIDA, National Institute of Trial Advocacy, I believe is
correct.
And you've taught there for?
Since 2007.
And can you unpack a little bit of what the organization does and why you might feel it's important? And to make my question objectionably long, we've had a few of our attorneys who've gone through it and actually been your students and have come back with just some amazing feedback in terms of the learning that comes from it. So who would it be right for in terms of our listeners and why?
National Institute for Trial Advocacy's approach is learning by doing. So if you take their trial training and deposition training programs, you're basically in with faculty and you're asking questions in depositions, you're defending depositions, or you're doing openings and closings and learning how to handle experts. And then at the end of the program, you actually try the case for a half day. So it's muscle memory that you're building. You're understanding concepts of where do I stand in the courtroom for direct, for cross, for closing, opening, and how do I become myself? And frankly, I started teaching in the program in 2007. I didn't have very much trial experience. I went and took the teacher training program thanks to Bernie. He signed me up and got me a scholarship. And it was Mike Kelly and Doris and a lot of, fantastic faculty who have far more trial experience than I ever will. And we did that the training. And then later on, to my surprise, I was invited to be on the faculty. And I'm like, really? You sure that you got the right email? But as I went, I realized I'm going and presumably to teach when in reality, I'm in the room with lawyers who are just these incredible orators. So selfishly, I go back all the time. As much as I love giving back to our community and mentoring, every time I go back, I learn something new from these incredible lawyers that are there who, you and I would be sitting in the room and you're giving feedback. I'm taking notes, right? Because that's what it gives back to me. So when I volunteer my time for these, hopefully the students leave being a little bit better, but also to ignite their curiosity and their passion for what they do, because we need more trial lawyers. We need people to care about this system and to help preserve it. And I think NIDA does an incredible job of that.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. You made reference several paragraphs back to your son being exposed to various things, including a verdict.
Yes.
And I'd love to hear a little bit about that case. I think the best thing to do, if you don't mind, is setting the stage a little bit by telling the story of what happened to your client and then some of the challenges in the case and then ultimately the outstanding verdict that you got.
So we represented a client who was 90 years old. She was profoundly deaf and she had dementia. She lived in a residential care facility in Santa Rosa, California. And that facility did not have a proper fire evacuation plan, despite the fact that 2 years before, another fire had come through and gotten so close to the facility that wheelchairs were burned and melted into the asphalt outside of that facility.
Wow.
So you would think fire evacuation, we know it's California. There's always a real danger of this happening. And there was a piece of evidence that never saw the light of day, which was they were cited for not having a fire evacuation plan for their skilled nursing facility, which is just next door. But the judge said that's not coming in because it's a separate facility, even though they had the same executive director, people working in both facilities, and they're saving money, right, by having an executive director that works both facilities. A fire came through and they evacuated. Well, they didn't have the proper plan. They didn't have reciprocal agreements with other facilities to move people to. So they had to move people to their sister facility that's 80 miles south in Saratoga. In that facility, 45 residents were put in a common room. It's like a large auditorium style room or conference room with cots and walkers and personal effects. Our clients, despite their attempts to say that they were watching everyone closely, had 2 unwitnessed falls within a 7-hour period. The second fall resulted in a fractured humerus fracture, which is an incredibly painful injury. They sent her without her hearing aids, no one accompanied her, to the closest emergency room, which is about 13 minutes away. The emergency room triages her, sends her back. Because nobody was with her, there's no pain medication, and she doesn't get pain medication for the next probably 13 hours. Now, the person is in that situation, right? They should be looking at how do we keep her and how do we take care of her. Instead, they decided we're going to ship her 80 miles north toward the fire evacuation zone back to Santa Rosa Memorial, which was the only trauma center that was open at that point. You and I have not had much medical training, but if we know that grandma is having a stroke or we suspect a stroke, we send her or take her to the closest trauma center. Well, they shipped her 80 miles north to Santa Rosa Memorial instead. And they denied that they suspected her of having a stroke. Yet their experts said, the reason her cognitive abilities went off the cliff after this event was because she was having microstrokes. Well, we found a medical record that showed that when the nurse at the emergency room called to berate the nurse who sent her to that emergency room, she said, the reason I sent her there was because we thought she was having a stroke. So she gets to the ER. And then after that point, they're unable to account for her consistently for 11 days. And she does not have her hearing aids. So this caused a massive drop-off in her cognitive abilities, her going from being able to walk for the most part on her own with, sometimes the assistance of a walker, standing and taking pictures and smiling with her son, to looking absolutely terrified every time the kids would FaceTime her. Because remember, it's October of 2019 and then it bleeds into 2020, which is now COVID. Then we started looking deeper and it turns out that in a 12 to 14 month period, she had between 25 and 27 falls at the facility. And the protocol in these facilities is that if somebody's having a fall, there needs to be some sort of an assessment to reduce or eliminate the risk of fall going forward. This was done only once. And after it was done, she fell 3 times and hit her head and had to be sent to the emergency room. So the defense basically came in and said, nope, we didn't do anything wrong. And I think the quote in opening statement was, we provided appropriate care. Their whole approach was that our client had passed away of natural causes during the pendency of the litigation. They felt that nobody was going to award an elderly woman who is no longer alive any money for pain and suffering because the money would eventually go to the kids and they were going to paint it as the kids put her in this facility, so why should they get any money? Well, the jury disagreed. So
significantly, it would appear.
It did. And the thing to put it in context is we had obtained a preference order for the case in 2021. So under CCP 377.34, her pain and suffering damages survived into trial. And that was obviously a new law that went into effect during COVID. So the jury did disagree, and they awarded $10 million for pain and suffering for what she had gone through during that year.
That's significant. Now, the total verdict was $32 million, correct?
Yes.
What made up the other 22?
The other 22 million. So there was 10 million for pain and suffering, 84,000 for economic damages, and then 22 million for punitive damages. And during the punitive damage phase in closing argument, again, the defense reiterated, don't hit us anymore. You've already awarded a significant amount of money. Ultimately, again, if you read between the lines, we didn't do anything wrong, which to me, again, maybe that's not how I would have done it if I was defending the case, and based on my defense experience.
There are always challenges in cases, and there are risks of exactly what you're talking about. The idea that the people who are going to get the money are the same people who put it in the facility. That's a little bit of a dangerous argument on the defense side.
Yes.
And just from a risk assessment, the idea of letting a case because it tried in Sonoma County, right?
That's correct.
And so this is a community that has been devastated by fires and understands the risk. You can always Monday morning quarterback cases, but it doesn't sound like an adjuster on that side was making some wise decision making.
I always say when you go to trial and a verdict comes out, somebody was wrong in their analysis, right? So in every case, somebody's miscalculating or is wrong in the way they were thinking, but that's what trials are for. And to me, one of the things that I wanted to make sure occurred is that, look, that's fine. You're allowed to have your opinions, and you want to force this to trial. That's fine. Let's go find out what a jury is going to do with this. And now we have an answer. And to me, what I'm particularly proud of is that when I decided that day that, when I was a kid in court, that I wanted to be like that person, I've always envisioned myself as, from a legal standpoint, because I'm certainly not tough enough to do this in real life, that I'm the person standing outside the door protecting the occupants inside, right? And personally, to be able to have a voice in that courtroom for somebody who was 90, had dementia, was profoundly deaf, and is no longer with us, was an incredible honor for me to do that. To be able to stand there and be her voice and to essentially make sure that she was seen and she was heard in that courtroom. And again, we can agree to disagree and go to trial, but ultimately, once that happens, don't come back to me and say, oh, how did this happen? Well, if you'd opened your eyes and looked at it as a human being, and again, my wife will tell you, I was talking to all of our friends like, hey, what do you think about this? What do you think about this? And she's like, okay, enough. Can you stop trying to get opinions? But that's who my audience is. My audience, I may call you and say, hey, Miles, what do you think of this? But ultimately, your approach is not what the jury is necessarily going to do. You're going to provide me a great amount of insight. But if we have a friend of ours who always tells me like, oh, this is the weakness in your case. And I'm like, oh my God, you're right. I work a lot harder to shore that up. And those are things that I think the defense wasn't paying attention to. Like, did you run this by a family member or a friend of yours to say, hey, what do you think would happen in this?
I have so many questions. I'm trying to figure out where to start. I'll ask the short one first. This your first plaintiff's verdict?
Yes.
Set the bar a little high, didn't you?
It is, and it's also the first elder abuse case I ever handled. So, I always joke that even the rookies sometimes get the grand slam home run, but it's also a product of having tried cases against incredibly capable plaintiffs' lawyers on the other side, right? So I always think of myself as a sponge, and the day you stop being curious is the day you should stop practicing. And to me, like I said, I would listen and watch your podcast because I love the way you conduct the interview. That's how direct exams should be done. And being able to be in the courtroom with these incredible lawyers and draw from their abilities and knowledge helps me build things. When I go to NEDA, I see this. When I go judge a mock trial, there's some phenomenal law students. I'm scratching my head like, wow, I got to try that. So that really is something in my mind that helped us build a case. But ultimately, it's about storytelling. It's about being able to convey and be the voice of another human being. And let's face it, jurors don't want to be in the courtroom. Yet we're going to make you sit here for 4 weeks and bore you? Nope. I have to make sure that the jurors are being entertained and are hearing a story that then they can take into the jury room and stand behind.
I want to acknowledge your comment on the podcast. I will say, much like your comment about you're taking depositions in the asbestos cases. This to me is the getting in the reps between the trials.
Yes.
And part of why I love doing it. The other piece is I get to learn from masters and people who have had the opportunity to just do amazing things.
And I appreciate you having me despite the fact that those people weren't available for this episode.
I include you in that category.
Thank you.
It's not luck when your first plaintiff's verdict is an 8-figure verdict.
Well, I always say luck is an intersection of hard work and opportunity. And I know a lot of lucky people who work their behind off, right? I don't know any lucky people who sit on the couch and don't do anything. So there is something to be said about that, where somebody says, well, oh, you do this or lawyers this or lawyers that. It's like, no, I've been working on my craft, as you have, for the last X number of years. And it's easy to say, I want to be a trial lawyer or I am a trial lawyer. We see this all the time, right? There's many lawyers running around claiming that they're trial lawyers. But there's very few people who are willing to do what I call the ditch digging that makes you a trial lawyer, right? And that's important because the successful trial lawyers aren't afraid of an objection going the other side's way. And if you have that mentality of the grit that I'm in here for the long run, and I may have the judge against me, the defense against me, and maybe the juries or some of the jurors against me. But if I believe in what I'm doing, I'm going to be creative about it. A lot of times that helps build something that the jurors can then take into that jury room and advocate for.
Obviously, you've never argued for punitive damages before.
Correct.
On the defense side, had you ever had to be in a position of protecting your client in a courtroom from a punitive damage demand?
I don't think any of the trials that I've ever done involved punitive damages, but certainly I've defended cases in which the plaintiffs were arguing for punitive damages, right? So I know what goes into the mentality of the defense in terms of how those are dealt with and the impact that it has when they're in play and everything else that goes along with it. But ultimately, you have to have a process in place that gets you in a position to get that information. And in our case, we had tried to do discovery. They objected. So I got a stipulation from them that if we did hit for punitives, they were going to produce the documents we asked for. We received, I want to say, a total of a tops 20 documents that were non-audited financial statements, which I basically went through with our expert, Craig Enos, and I hesitate to say his name in this podcast because I like having him to ourselves, so to speak. But that allowed me to go through and basically put holes in their arguments about, oh, we don't have money and this, and that, right? But the other piece of it is we issued notices to appear at trial and subpoenas for a PMK on these issues, as well as the documents. And if they don't provide all the documents that you're requesting, to a certain extent, that absolves the plaintiff of the burden of having to show the defendant's net worth. So by doing that, we put ourselves in a position for success. So they came in and they said, we don't have any money. Here's our financials. And well, the financials don't necessarily account for the cash that's being sucked up into the parent corporation. Okay. Well, are these audited? No. Well, how about this one? This one is significantly lower than all the other financials. Oh, that's for the last 4 days of 2022, let's say. Well, where's the rest of it? Oh, I wasn't asked to provide that. So all of those helped in the cross-examination of this controller. And ultimately, two of the questions I asked them at the end of the cross were, how much does the CEO make? Objection, privacy, sustained. Well, do you tell your investors that for the last 4 years, your company has been losing money? Objection, argumentative, sustained. All right, let's take a look at the shareholder equity of the company. It was $17 million in 2019. It's $202 million in 2022. That's right. And the jurors are laughing. Why?
Wow.
How does the shareholder equity go from 17 million to 200 million if the company is losing money every year? So the credibility of these witnesses, and I think we caught probably 4 of their witnesses, not, to be generous, accurate. And that really was something that the jurors looked at. And again, you're building your case and telling your story, but on the defense side, you have to make sure that you're not doing things that are going to make this jury upset. That not only have they been covering this up, and my theme in the closing was trust, betrayal, and denial. Our clients trusted that they were going to do their job. They were betrayed, and now they've been denying it. And to this day, they stand before you and deny that they did anything wrong. And people don't like being lied to, especially 12 of them who have the power to spank you.
Yeah. Was there any outreach between the phase 1 verdict and the phase 2 verdict from the defense in terms of uncle, you got us. Let's talk about tying this off?
I wouldn't say it was uncle. It was, let me show you part of a white flag, but then ignore you because I still don't believe your case is worth anything.
After a $10 million verdict, they don't believe your case is worth anything?
Again, my take on it is, okay, you think I don't know what I'm talking about, right? Their view was, you're not an elder abuse lawyer. Okay, fine. But I know how to read the law. I know how to read the practice guide. And I know who to call to ask questions, so I'm up to speed on this, right? And once the jury hits you, then I'm not the idiot telling you that you're wrong. You have 12 people who have the power to tell you even more how wrong you are. So the closing argument basically was that, hey, we didn't do anything wrong. Please don't hit us for any more money. And my response was, they're still in this reality distortion field. You've already found that they're liable. The question is, how much money do you award to punish and deter them from ever doing this again? And the jurors came to a conclusion that this was an appropriate amount to do it.
Was that something that you done any sort of focus group or any other type of preparation beyond the conversations with friends, neighbors, colleagues to help you kind of fine-tune your themes?
I think this is part of my defense experience where my former firm rarely did focus groups or, mock trials. I think I was involved in maybe 3 my entire career there. So I'm not used to doing it. So I didn't do any kind of focus group or, a mock trial on it or anything like that. And it was just simply talking to normal human beings to dial in my arguments and really going to my roots as storytelling, right? Because I think if you look at it, there are some incredible Iranian trial lawyers that are out there. And I think part of that is Iranians by nature, we're storytellers, right? You look at the Shahnameh, this is an entire story written in poetry, right? So to me, I was just mentally in a space where I believed and cared for our clients so much that I just felt like I could channel who she was, even though the jurors never saw, her testify, not on video, nothing. And I felt like the story and the universe was behind us in terms of telling this story. It may sound corny or naive, but at the end of the day, it was one of those things where I was just so honored to be in that courtroom, to essentially do this for the family, even though she never got to see the results. I joke that I have this thing about butterflies, and we're sitting there to one of the last days of trial, and this massive butterfly comes and lands above us. The universe is a big place. This happens, but at the same time, I felt like this was something that landed with me in terms of fueling me to go forward and do something that was very much outside my comfort zone. As a defense lawyer, you're not too worried about logistics of trial, but as a plaintiff's lawyer, God forbid, you don't have your witness there and the judge says, counsel, now you've rested. Oh my God, I worked, 3 years on this case and now there was a logistical issue and you're going to tell me I got to rest my case. And so those are things that really drive you. But at the same time, I look at it as I'm sitting there and I'm being the voice of somebody who didn't have a voice in this situation. They never asked her, hey, do you want to go for a 90-mile drive without pain medication with a fractured humerus bone and no hearing aids? Right? Guess what? You didn't listen to her or get her input. You didn't see her. Now you're going to see her. And that's what we were there to do.
Any other learnings or takeaways that you would like to share with our listeners from that case?
Obviously, the preparation is important, right? The verdict doesn't happen unless you've worked up the case. We put a tremendous amount of time into that case, and there was probably over 4,000 documents that were involved in that case. I read through each and every one of them probably 3 times, right, in order to get familiar and then compile it. But one of the things as a trial lawyer, and again, I have limited trial experience, by, ABOTA standards, right? But one thing I've learned is that there are a lot of trial lawyers out there who believe in the foam board and the butcher paper, when in reality, that ship has sailed. And using an iPad, which I do to try the case, and I control the whole thing. Like if I do a call out, it's me. If I do a slide, it's me. That approach tends to resonate with jurors because they're used to visual displays with high resolution imaging. And if I can do that, then the story matches up to something visually. And instead of remembering 30% of it, you're remembering 70% of it. And I think that was a huge piece of it because the jurors had recall of specific events because it matched up to slides that were on the screen. And I'm not talking about a slide with 70 bullet points. I'm talking about clean slides with very few bullet points where they can take comprehensive notes and use it in the jury room, right? Because ultimately, if the jurors are going to go into that room and have a discussion, they better be armed with facts when somebody says, oh, this happened. No. During Milanfar's case, he showed us X, Y, and Z, and this is what actually happened.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.